Yes, be ready for the dictation. Start. Learned counsel for the petitioner has argued that the conduct of the accused persons was completely ignored by the additional sessions judge while accepting their third anticipatory bail application while impugned order dated 18/6/2020 and even the objection that they were proclaimed persons was not dealt with stop. He has further argued that the previous two applications filed by the accused persons were withdrawn by their counsel and the third application could not have been entertained as there was no change in circumstances. Therefore, the impugned order warrants interference. Stanza. Learned counsel has argued that neither the maintainability of the application was examined nor the directions issued by this court were complied with by additional sessions judge while accepting the prayer for anticipatory bail on behalf of proclaimed persons. Stop. In support of his arguments, learned counsel has relied upon decision of this court. Stop. He prayed that the impugned order be set aside. Stanza. On the other hand, learned counsel for the respondents has argued that as the previous two petitions filed by the accused persons were withdrawn and were not decided on merits, therefore the same shall have no bearing on the application which has been accepted on merits. Stop. According to him, the additional sessions judge has considered the facts and circumstances of the case and exercised the discretion in favor of the accused. Therefore, the complainant cannot maintain this petition under section 439 as the said concession has never been misused by the respondents. Stop. He further states that as the respondents have already joined the trial proceedings, therefore the petition deserves to be dismissed. Stop. In support of his case, learned counsel has relied upon passed in by this court in and prayed for dismissal of the petition. Stanza. During the course of hearing, it is not disputed by the learned counsel for the respondents that after withdrawal of the second anticipatory bail application on 17/1/2020, there was no material change in circumstances and the third application was also filed only on apprehension of arrest. Stop. He has not explained that as to why the earlier two applications were not pressed by the accused persons. Stanza. Learned counsel for the parties have been heard and with their assistance perused the case file. Code of Criminal Procedure contains provisions relating to bail and bond and section 438 CRPC confers discretionary powers upon the High Court and Court of Sessions to issue directions for release of person apprehending arrest. Stop. Section 438 CRPC reads as under. Stanza. When any person has reason to believe that he may be arrested on an accusation of having committed a non-bailable offense, he may apply to the High Court or the Court of Session for a direction under this section, and that court may, if it thinks fit, direct that in the event of such arrest he shall be released on bail. Stop. If such person is thereafter arrested without warrant by an officer in charge of a police station on such accusation and is prepared either at the full stop over